Welcome to Sakshi TV's special immigration show with attorney Mr. Chand Parvathaneni, the managing attorney of law firm of Sir Parvathaneni and Law. Please note that Sakshi TV now has four immigration shows every week. On Tuesdays with Mr. Kaveti, on Wednesdays with Ms. Prashanti Reddy in English, and on Thursday with Mr. Chand Parvathaneni, Fridays with Banu Nindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at sakshi.com or call us at 8667257441. Before we begin the show, please note that the information provided on the show is not a legal advice and for general informational purposes only. Sakshi TV or its agents will not be responsible for the use of information. Mr. Chan needs no introduction, but if you need any direct consultation, please log on to spblawfirm.com site for contact information. And if you don't forget to mention Sakshi TV if you ever go to them. Mr. Chan's law firm has been very helpful to a lot of people, especially in USA, for terms related to immigration H1Bs. So without any further delay, let's welcome him onto our show. Mr. Chand, I hope you're doing well. Welcome back to our show.
Thank you, Shivani, and thank you all Sakshi TV viewers. It's nice to come back on the show and discuss a couple of more updates and things that are happening in the immigration world.
Yes. So, Mr. Chan, without any further delay, let's get on to the latest immigration updates this week. So, can you tell us, are there any updates that we have to know before we get into the topic?
So the main thing is it's a good thing. We are seeing more and more slots being available for the H1B applicants in India. It's welcoming news because many have not been able to get visa appointments for a long time. And starting November, so last 30 days, we have seen a lot more slots being opened up, and people have been successful in getting visa appointments and not having to wait for a couple of months. So for any H1B applicants, either Dropbox appointment or even interview appointments, for H1Bs, things are starting to get a lot more smoother. However, for the B1, B2, we are still seeing challenges in India, not able to get appointments in India. That being said, there are a lot of B1, B2 Dropbox slots being opened up. So hopefully, in the next couple of months, as things get smoother, the long wait time. Right now, we are almost talking about 1,000-day wait time for the new B1, B2 appointments. Hopefully, that is anticipated to come down in the near future. And coming to the green cards, the EB2, EB3 dates, unfortunately for Indian nationals, it is not progressing like we wanted to. EB3 is at least moving ahead, even though it's slow, it is still progressing. EB2, on the other hand, the EB2 green cards, unfortunately, because of retrogression, they have moved back. And hopefully, the next couple of bulletins hopefully will move it further up. Long term, we do think that EB3 will not cross EB2. Hopefully, I think that based on the number of filings that you're looking at, EB2 at some point of time more than likely will cross EB3 again. And to me, it just looks like it's a temporary thing where EB2 is ahead of EB3 is ahead of EB2. And then the most important thing, recently, if you look at the news, we are hearing a lot about the tech layoffs. Layoffs are always bad, and it's even bad for anybody on H1B. Because when somebody's on H1B, there are so many other things to consider when there is a layoff. And that being said, yes, we are hearing about layoffs in tech sectors, big companies like Amazon, Facebook, all these companies are talking about layoffs. But at least in our law firm, we are still seeing a lot of transfers happening, a lot of H1B petitions being filed. So it is not really true that we are in the middle of a big recession yet. Maybe down the line, things could go bad. And what that means is anybody that's on H1B should be educated about what a layoff means from a H1B perspective, what to do if somebody is in that situation, how to be prepared in case there is a layoff. I mean, let's all hope that nobody gets laid off. But to be practical, one has to be ready because from an immigration perspective, there are so many things to consider. And this is what we will discuss in the show today.
Yes. Like you said, Mr. Chand, we were going to discuss about the job layoffs. So first of all, there are unfortunately a lot of layoffs, especially in tech companies, and there are also, unfortunately, many H-1Bs employees visas are also impacted. That there are apparently rumors saying that if you lose the job, you'll also lose the visa. That means you have to get back to your country, you have to leave the country. Some are also saying that you can still stay back a few days. Are these rumors true? And what is your view on this, especially?
Yeah, so layoffs can really mean tough times for H1B workers. And the reason for that is because they have a very limited time to find a new employer. And previously, 1990 to almost 2017, the rule was that there was no grace period. Somebody loses their job, somebody on H1B loses their job. Technically, they fall out of status the very next day. And what that means is somebody on H1B back until 2017, they did not even have enough time to sell or even dispose their personal property. They had to depart US right away. So things were bad. There was no grace period. Luckily, some new regulations took effect from January of 2017. And what these new regulations do is they give a 60-day grace period after the employment is terminated. And what this means is the H1B employees, in case they're laid off, they have 60 days after the last day of employment to find a new employer. And what finding a new employer means is the new employer must be willing to sponsor their new H1B petition. And not only that, within the 60 days, the new H1B petition has to be filed. So basically, it is true that in the past, one had to leave the country the very next day. But at least in the current rules, the rule is 60 days. So in 60 days, one needs to find a new job. And in the 60 days, even though they're not working, the H1B employees are considered to be in valid status. And from a state perspective, they don't accrue any illegal status until the 60-day grace period is completed.
Yes. So, Mr. Chan, let's get into, what if somebody loses a job? So, how does USCIS generally know? Should the employee go and notify that, oh my God, listen, my H1B is, my job has been lost? Or does the employer, before, removing them, has to go and notify the USCIS? How does this work?
So the employee does not have any burden of notifying USCIS. So the employee does not have to go to USCIS and notify that they lost their job. However, the employer by regulations has the duty to notify USCIS. So technically, the employer, they are supposed to notify USCIS immediately whenever they terminate somebody on H1B. And most of the time, the employers do go and notify USCIS. And there is a reason for that. So the Department of Labor, so they have clarified that employer is going to be subject to penalties if they fail to notify USCIS. And what that means is if the company does not notify USCIS and for some reason there is a DOL audit or something happens, the company might be liable for back pay, the wage payments. So due to this reason, the company does not want, even though the company does not want to harm the employees' interests, they have to protect their interests. They are bound by the law, and they are subject to penalties if they do not notify USCIS. So technically, for all practical purposes, what really happens is the employer goes and notifies USCIS. That is number one. Number two, when the employee goes and gets a new H1B transfer petition filed down the line, USCIS also looks at the pay statements. So that is another way that USCIS will find out. So because of all these reasons, whether USCIS knows about it or not, the employee has to be aware that he has only 60 days, and within the 60 days, they are supposed to find a job. And not only that, when a layoff happens, the employer, by law, they're not only supposed to notify USCIS, they're also supposed to offer the airfare for an H1B employee to go back to their home country. So all of this typically happens during a layoff. So one, even though even though the USCIS in their particular case was not notified, they have to be aware that they only have 60 days, whether the employer notifies USCIS or even if it doesn't, get notified, it doesn't matter. I mean, one has only 60 days to find a new job.
Yes. So basically, Mr. Chan, in USA, there are a lot of, if one is unemployed, they have something called as the unemployed benefits that they get. So can a person with H1B who just lost their jobs, can they get any employment, unemployed? They have these programs like we discussed.
Right.
So can they get any benefits from this unemployment programs?
Right. So in general, like anybody in US who is working, somebody on EAD card, somebody on green card, somebody on some other, uh, uh, I mean, various employment statuses, US citizen. If they lose a job, most of the time they are eligible for unemployment benefits, most of the categories. However, for H1B, it is a little bit different. The H1B workers are ineligible for unemployment benefits. They should not apply for unemployment benefits, and they are actually not eligible for it. And there is a reason for it. So the law is most of the states where unemployment benefits are given, and again, the unemployment benefit rules are different in each state. But however, the general rule is that most of the states where unemployment benefits are provided, they require the employee to be available and ready to take up work. And so, what these benefits do is, if somebody is ready to work and they cannot find employment, the unemployment benefits help in paying some amount of money, so people are not coming onto the road. So it is going to help the employee who just lost his job. So if a green card holder lost his job, they apply for unemployment benefits, and depending on the state where they are at, they get the benefits. The reason H1B employees cannot get those benefits is because one has to be available and ready to take up job.
Okay.
For H1B employees, it is a little bit different. They're not available, they're not ready for work unless the employer files a H1B petition. And technically, until an employer files a H1B petition, we cannot claim that the H1B employee is ready to work readily. So for this reason, H1B employees unfortunately do not get any unemployment benefits because no employer has an obligation to hire an H1B worker or petition a H1B petition. So because an H1B employee who remains in the United States after the employment is terminated is technically illegally present unless they're within the grace period. So overall, what this means is one should not have gaps in status. One is typically required to depart US within their grace period or find a new job. And unfortunately, they cannot apply for unemployment benefits and they're not eligible for these benefits.
Yes. So, Mr. Chand, let's just say that somebody has lost their job, and especially the employee is taking a lot of, more than 60 days. So, let's say they got the job in next 75 days. So, will that affect anything, and will this ruin anything? Can you please share your thought on this?
Sure. So the rule is one generally only has max of 60 days to find a new job. And the new employer not only find a new job, the new employer is required to file the new H1B petition before the 60 days is over. And filing the petition takes some time. Typically, it takes about 10 days. You have to get an LCA certified. You have to get the file ready. You have to submit it to the USCIS, the Right Service Center. They have to receive the file. So one also has to account for all this time period. So 60 days is technically not a time to find a new job, but 60 days is the time to finish the process of finding a new job and the new employer technically filing for the H1B petition. And in case, say, the employee takes more than 60 days to get this process completed. In most situations, USCIS will not grant the status request. What that means is USCIS will still approve the case. They will not deny the petition. However, they will only approve the petition for consulate processing. What that means is the employee has to leave the country. They get the approval, but they still have to leave the country, and they have to come back with a valid H1B visa. So the problem is you cross 60 days. Yes, USCIS could still approve the case, and more than likely they will still approve the case if everything else is good. But one has to leave the country and come back with a valid H1B visa because there is something called I-94. The I-94 will not be granted if one crosses 60 days. So be cautious. The H-1B can still be approved, but you will not get an I-94, and that means that you have to depart out of the country and then come back with a valid visa.
Yes. So, Mr. Chand, my next question is: can one, who lost their H-1B, still legally stay in the country even after 60 days?
So there are ways if one needs to stay back in the country, and one has to proactively take proper precautions, proper measures, and everybody's personal situation is different, and depending on the situation, there are various ways. Say, for example, one who's on H-1B just lost their job, but they have a spouse who's also working in the country on H-1B visa. And then for them, the easiest option is convert to H-4 visa, to H-4 status. And doing so, they can stay back in the country. And what that means is proactively, they have to take some steps to apply for H-4 status. Similarly, if their spouse is on L1 status, then filing for L2 status is another option. And to qualify for a change of status, for example, to H-4, the H-1B employee technically must have a spouse that's in a valid H-1B status. And what that means is not only they hold H-1B status, they should also be working, getting paid like they should. And then on top of it, you're supposed to file an I-539 application. It has to go to USCIS within the 60-day grace period and pay the proper fees. If they do that, yes, they can stay back in the country. And what some people also do is they file for B1, B2. B1, B2 is a tourist visa. It is not recommended, but depending on one's own personal situation, in some situations, it might be appropriate to file B1, B2, depending on the situation. But definitely, I mean, think twice before filing a B1, B2, because if you really have a reason that you can justify, yes, B1, B2 is an option. But if not, you have to be cautious. And in our own law firm, we had cases during COVID time where people lost their jobs. They were not able to get a new job in 60 days, and they could not even travel out of the country. So they had a valid reason where they had to stay back in the country because of various travel issues. So in that, for example, in such a case, B1, B2 might be a valid option because B1, B2 is typically for tourism or business. So depending on your situation, it may be a valid option. Another option some people do is they go out of the country. They get a H-4 visa because their spouse is in H-1B status. They come back. They apply for H-4 EAD. So this can be done even without leaving the country, but some people decide to go out of the country, get H-4 because they can get the H-4 stamping a lot more quickly than filing for change of status. So there are various ways, but the crux of the matter is proactively apply for something where you will get back into a valid status. Because if you cross 60 days, you will lose status. But if you file for a change of status to another valid uh, visa category, then you can stay back in the country. Another uncommon option that we occasionally see is changing to student status. Somebody's on H1, they lose their job. Some people, they go apply for some program, some master's program or some PhD program. They get an I-20, and then they come back and apply for change of status using I-539. And as long as they do it within the 60-day period, changing to student status is also an option. So some people decide to do that, and there is nothing wrong about changing to student status. The only thing is there are various ways one has to make sure they're following. Make sure they go to the school, they get an admission, they get an I-20, they pay the service fees, and so on. So there are various ways. And by doing so, one can stay back in the country even after 60 days.
Yes, now that you've mentioned that, let's say that one is changing the status from, you know, from from F1 and then, or H4 or D1 or D2 to the H1B. So, does they have, do they, can they change it easily, or do they have to go through the lottery process again, Mr. Chan?
So this is another concern. A lot of people do want to change to another status temporarily, for example, say H4 or some other status. But the concern is once they get out of H1, can they really come back to H1B easily once again or not? or do they have to go back into the lottery and go through the entire lottery and cap and all that lengthy process? So the good news is one is considered cap exempt for all future H1B petitions most of the time. The only criteria is they don't complete their 6 years on H1B or they have an I-140. So what that means is even if temporarily they do convert their status to H4 or temporarily convert their status to B1, B2 or say F1, in the future, say they find a better opportunity, better job where the employer is ready to sponsor their H1B, they can immediately come back onto H1B status again. So it is not a tough thing. And what this means is they just have to make sure within the 60-day grace period, they did convert to another status. So, or they left the country. So basically, all we have to prove is their status is not jeopardized, and or they left the country. If that has happened, they are cap exempt. So anytime they find a new employer, the new employer will file a H1B petition. They don't have to go through the lottery. And once the new employer files the H1B petition, they can get back onto H1B status. The only rule is that if they find a new employer within 60 days, say for example they filed a H4 change of status within 60 days, but again within 60 days itself they found a new employer. That is very straightforward. They can start working for the H1B company right away. But say the 60-day period is crossed, even then the process is easy. But the only caveat is that they have to wait until the H1B is approved. So the H1B employer files the H1B petition, they get an approval, and immediately they can get back onto H1B. So it is not that difficult. So it is not that once you file change of status, you are stuck with that new status. No, you can always get back again into H1B down the line, even if it is after 60 days. So even after 1 year, even after 2 years, even after 3 years, if they find a new employer, they can always get back onto H1B without the hassle of going through the lottery process.
Yes. Now, Mr. Chand, let's say that the H1B holder has had his job terminated and has left the country already. Can they still use the old H1B stamp and get back to the country, or do they have to go through the lottery process all over again?
So, so, so the good thing is, say somebody has a valid H1B, they lost their job, they have a valid H1B visa, and they left the country. Say 6 months down the line, they found a new employer. The new employer filed a H1, and that H1B also got approved. So the good thing is they don't have to go for visa stamping once again. So they get a H1B approval. They can use the same old H1B visa that shows the name of their old employer. They can use the same H1B visa to come back into the country. The only caveat is that the H1B visa has to be valid. What that means is the H1B visa, if they look at the H1B visa, there will be an end date. So if the end date has not crossed, say for example, the current H1B visa is valid till 2024. So before 2024, if they find a new employer, they can use the same visa, same old visa with a different employer's name. They can carry that visa, they can carry the new H1B approval and enter US. So the new employer does not have to send the employee to a new H1B stamping. The old H1B visa, if it is valid, the old H1B visa can still be used even if it does not show the new employer's name on the H1B visa.
Yes. So, Mr. John, let's say that one has a previous pending I-485 and they lost their job. The same thing. And can they stay for 60 days, or can they stay for more 60 days, or do they have to leave the country immediately? What's the whole thing?
So if they have a 485 application, 485 application is basically a pending green card application. It is the last stage for the green card. So it is a pending green card application. The good thing is, if at all somebody has a pending green card I-485 application, they are considered to be an authorized status. And what that means is losing your job does not automatically jeopardize one's status. They are allowed to live in the country. They are allowed to stay in the country until USCIS finishes the adjudication of I-485. Luckily, they don't come under the 60-day grace period. They can stay in the country. However, what a lot of people do is, a lot of people want to also maintain their H1B status while their 485 application is pending. So technically, if you want to maintain your H1B status, you have to find employment within 60 days. But if not, if the 485 is pending, they are good to stay back in the country. And as a matter of fact, pretty much every applicant for 485 also will file an EAD application, employment authorization application. And if they get the EAD card, they are free. They can change their employers, and they don't have to really worry about the 60-day grace period. So, in a way, they have a lot more flexibility, and they don't really have to worry about the green card process starting all over again. So, there are different rules. So, they still have to find employment, but at least the 60-day, that whole stress is not there, and they don't really have to worry about the whole pressure about leaving the country in 60 days. They don't have to go through that pressure.
Yes. Chan, we only have 5 minutes left, but I do want to cover what exactly are AC 21 provisions for the I-485 applicants. Can you explain what are they and how does this AC 21 provisions help with people whose job just got terminated?
Sure. So, an adjustment of status applicant who has a 485 application pending for 180 days or longer, what this AC21 rule says is that these folks can continue their green card process even if they change their employers, even if they lose their employment and get a new employer. And there are some rules on what is required. That is pretty much what AC21 is. And specifically, AC21, it permits an individual to transfer or port his green card process to a different employer. The only rule is that the new job has to be in the same or similar occupation, and the I-140 is either approved, the underlying I-140, or it should be approvable when it was filed. That's all it means. So as long as somebody decides to change their employer after 180 days, AC21 rules kick in. They do not have to worry anything about them having to restart their entire green card process. And again, for this AC21, there are two opportunities to file AC21. One, whenever the 485, the green card pending applicant, whenever they find a new job, they can go ahead and file the AC21 notification. And all this means is go to USCIS, notify them that you have a new job, submit the new I-485 supplement J. That's it. That's how easy it is. So they can do that. Or there is another option. The other option is don't do anything, just wait for an RFE. If USCIS either issues a request for evidence or a notice of intent to deny down the line for 485, you can always file AC21 notification at that time and submit your I-485 supplement J. So technically, the 485 applicants, it's a very, very good feature, the AC21 feature, and that really helps whenever you have to change employers once you cross the 180-day time limit.
Yes. Finally, Mr. Chan, can you conclude the show by giving any tips or suggestions to people who are going through the tough time? Maybe their jobs got terminated. What is, as an attorney, what are your suggestions to the viewers watching the show?
Sure. So the first thing is, I think I see a lot of people getting very, very concerned about layoffs. And just to give my example, I came to United States about 22 years ago. So I came in year 2000, and I saw the first recession in 2001, back when we had this unfortunate 9/11 incident, where it was a very, very sad thing, and a lot of people lost jobs, and things were very bad. And then I saw another recession in 2008. So it's a cycle. So recession is a cycle, at least that happens, and things move on. And layoffs are not, I mean, even though they are scary, people in the tech industry, it is not something that people really, really have to stress a lot about it, because all the Indians who are on H1B, who are in US, they are highly talented. If not for that, their talent, they will not be getting paid such high salaries. The H1B salaries are very, very high, because the LCA requirements make the employers give such a high salary. And if the employers are hiring such talented employees with such high salaries, people, there is a reason. The reason is that people are talented. So in spite of a layoff, tech industry is something where things have to keep on going. You cannot just stop everything in one fine day. And what that means is this recession talk or whatever this layoffs are happening, it is very, very temporary, and people will find a job, because that's what I've seen in two recessions that I've experienced in United States. And recession will be very temporary. And the big thing is employees are talented. Employees have skills in the tech industry. So nothing to worry. It's a short term thing. And luckily, the government regulations also give grace period. So nothing that things are over. Things people will be able to recover. The only thing is be educated of what a layoff is, what happens in terms of H1B, what are the regulations when layoffs happen. So people are prepared. So when people are prepared, they immediately know how to recover, how to find a new job, what are the time periods. So that way, long term, they don't have to worry anything when they apply for a green card. So overall, don't panic. Just know the regulations, know the rules, and be prepared.
Yes. Thank you so much, Mr. Parvathaneni, for joining on to our show. We had an amazing show. Let's catch up next week. Thank you for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.
Thank you.